Edna Brazil was the hero, and what a remarkable lady. She went home and lived out her life there, watching these kids all around her on her family farm, learning about the environment and how to protect our state. I feel privileged to have known her. When you drive from Seattle to Yakima, there's a different route that everybody misses. It's the beautiful and scenic Yakima Canyon Drive. Instead of staying on the freeway to Ellensburg, just veer to the right and follow the old road down the canyon. The Yakima Canyon is an incredible place. The old road went right along the river. You can still take it today as a scenic drive. It's a little slower than the freeway, but it's really worth the trip. In the summertime, you'll see rafters on the river really enjoying the water. And through every season, you'll see different types of activities. People enjoying this scenic and beautiful valley. It's truly one of the most beautiful drives in our state, and it most certainly is one of my favorite places. When you go to the State Fair in Puyallup, two things are on your mind. First, the taste of those tremendous cones. Let's go. Secondly, a ride on the roller coaster. This beautiful old coaster, built in the 1930s, now rebuilt a couple of times, it's still just as exciting and just as fun. I remember coming here, I think first in 1956 or 57, and the first thing we wanted to do was get in the line for the roller coaster. It was going to be the best ride we'd ever had. There's nothing like the roller coaster. I've been doing it since the 1950s. The roller coaster is one of my favorite places.
All right, good morning. Thank you all for being here. My name is Paige McElrath. I'm the Director of Communications for the Citizen Action Defense Fund. I'd like to welcome you here to the media availability on the income tax challenge. Before we reach the Q&A portion, CADF Executive Director Jackson Maynard will provide an overview of our plaintiffs and what this lawsuit entails. He will then turn it over to Rob McKenna and Phil Talmadge, who will discuss the legal claims in greater detail. From there, we do have two plaintiffs that will be making statements, and then we will open the floor for you all to ask your questions. I'm sure you all have a lot of very insightful questions, but please raise your hand via the Zoom feature. We will call on you and take questions as they arise during the Q&A portion. Thank you all again for being here, and with that, I will turn it over to Jackson Maynard. Jackson?
Thank you, Paige. Again, I'm Jackson Maynard, Executive Director and Counsel for the Citizen Action Defense Fund, and I also want to welcome you to this press availability to discuss and formally announce the legal challenge to the state income tax in what I think is no exaggeration to describe as one of the most significant cases in the history of our state. CADF is a legal nonprofit that is dedicated to serving as champions of hope and accountability here in Washington State. We fight for transparency and constitutional government. We are joined in this legal challenge by a group of plaintiffs, individuals and organizations from around the state who I would like to introduce first. The individual plaintiffs include a residential and commercial builder and his wife, who is a small business owner, who reside in Chelan County, Benjamin and Laura Petter. We also have a farmer, Rob Mercer, and his wife, Brenda, whose farm lies along the Columbia River in Benton and Klickitat counties. And we have a trucker and company owner, Nick Nuccitelli, and his wife, Beatrice, who live in Kent. These are people from all over the state who work their fingers to the bone every single day, taking care of their families, employees, customers, and clients. They're building homes and offices, they're putting food on the table, and making sure that goods are transported so that people in our state have what they need. We're also proud to represent 4 outstanding trade associations that comprise a cross-section of businesses and industries that are negatively impacted by this unconstitutional tax. The Building Industry Association of Washington is the largest business trade association in the state, representing over 8,000 members in the home building industry. The Ethnic Chamber of Commerce Coalition is a significant voice for small businesses in the greater Seattle area. The National Federation of Independent Business is the voice of small businesses in Washington State with over 6,000 members here. And last but not least, the Yakima and Klickitat Farm Association represents the local farming communities that are harmed by this tax. We are so glad in this legal fight to be joined that it would be led not only by CADF, but also by Rob McKenna and Phil Talmadge. Rob is a Republican who's a former Attorney General and partner at ORIC, in addition to being an experienced litigator on constitutional and taxation issues. Phil is a Democrat, former Washington State Supreme Court Justice, former Senate Judiciary Chair, and partner at Talmadge Fitzpatrick. He's one of the best appellate advocates in the state. We could not be more pleased to have such a strong and bipartisan legal team to lead this challenge. I'd now like to turn it over to Rob and Phil to walk us through the legal claims in the case. Rob, if you could begin.
Thanks, Jackson. It's a pleasure to be teamed up with former Supreme Court Justice Talmadge again. Phil and I teamed up to overturn Seattle's illegal income tax some years ago, and that case is very similar to this case. We were challenging an illegal, unconstitutional income tax that clearly flies in the face of the Constitution, of precedent, and of voter will. Let me go through each of those points. What we're saying is that the state income tax is clearly unconstitutional and illegal for 3 essential reasons. Number one, the plain language of the Constitution. This language was put in by the voters to expand the Constitution's definition of property to be as expansive as possible. Its property is defined as everything, whether tangible or intangible, subject to ownership. A series of Supreme Court decisions have reached the obvious conclusion that income, being part of everything and being an intangible and being subject to ownership, is covered by that definition of property. That means Washington State can have an income tax if it follows the rules for property taxes. It has to be uniform and no higher than 1%. It isn't just one Supreme Court ruling that reached this conclusion. It has been a series of decisions by the Supreme Court that have looked at the plain language of the Constitution and reached the obvious conclusion that under Washington's Constitution, income is property, and that if supporters of a progressive income tax that doesn't conform to the rules of a property tax want to change that, the path is clear. They need to amend the Constitution. And that leads us to the third reason that the Supreme Court and the Superior Court in this case are going to block this tax. Voters have expressed strong, clear preferences for the existing law for many, many decades. They have been offered no fewer than 6 proposed constitutional amendments that would either exclude income from the definition of property or otherwise allow a graduated property tax. They've turned all 6 of those constitutional amendments down. They've also rejected 4 proposed initiatives that would have created a graduated income tax without amending the Constitution, which would have made them constitutionally flawed. But voters, in any event, rejected all 4 of those proposed initiatives, most recently in 2010. So we have clear language in the Constitution, which was voted in by the voters, has never changed. Its meaning has never changed. We have a series of Supreme Court decisions that have all reached the same conclusion, emphatically concluding that income is property and therefore income taxes have to follow the rules for property taxes. And we have no fewer than 10 voter decisions to keep the language in the Constitution the way it is or otherwise reject a state income tax. So really, the law could not be clear here, which is exactly why the Superior Court and the Court of Appeals invalidated Seattle's income tax, and it's why the courts are going to invalidate the new state income tax, which, by the way, legislators knew was unconstitutional. They have said publicly, well, we know that the Superior Court is going to invalidate this tax, but don't worry, it's going to the Supreme Court. What they're saying is, we know this is unconstitutional. We know this is illegal. We voted for it anyway, which means implicitly that they violated their oath to uphold the Constitution and laws of the state. And we, the legislature, choose not to do what all the other legislatures have done, which have wanted a graduated income tax, which was to send a constitutional amendment to the ballot to allow voters to decide. This legislature is doing everything it can to avoid giving the voters a say. They don't want this issue to be in front of the voters. They're hoping the state Supreme Court ultimately will decide that the unchanged words of the Constitution suddenly mean something different than they plainly mean, and that every Supreme Court panel before has concluded. So with that, let me turn it over to former Supreme Court Justice Talmadge. While he's speaking, I can tell you that this case is being filed in Klickitat County in the Superior Court, and copies of the complaint will be available later. Phil?
Thanks, Rob. And I'm here and proud to be representing the Ethnic Chamber Coalition. You're going to be hearing from Mike Sotelo of that coalition subsequent to our remarks. I don't need to go into greater detail than what Rob's done. I think it's very clear that there's a line of Washington cases that provide that income is property and the uniformity clause of the Washington Constitution applies. As Rob mentioned, back in 2019, we joined in securing a decision out of the Court of Appeals invalidating the city of Seattle's graduated net income tax on those grounds. That decision is probably the most recent of the decisions on that point, and it is unambiguously clear that the uniformity clause applies, and the Court of Appeals struck down that effort by the city of Seattle to impose a graduated net income tax. I've been involved as a legislator in efforts to secure tax reform that included an income tax. I support the idea of tax reform in Washington that could include an income tax, but we did it by a constitutional amendment. We came very close in the 1983 Washington legislative session in enacting such a provision that would have provided for an income tax, but would have substantially diminished sales taxes, property taxes, and a variety of other taxes in a revenue-neutral fashion, securing real tax reform and placing it in the Constitution. We didn't get there that year, but there were predecessors to that legislation that attempted to do so got on the ballot, and as Rob described, the voters did not vote for it. The bottom line here is the legislature has to enact this kind of change in the law by a constitutional amendment. They are hoping that the Supreme Court will change its view about whether or not income is property. That is an open question. We're going to be litigating that issue yet again, but we're assuming the court will follow its prior precedents in this regard and will uphold the principle that income is property in Washington and the Uniformity Clause applies. Now, there are other challenges to this legislation that are possible. The initial complaint that you all have received a copy of provides for that uniformity challenge, but there are other issues that we're exploring. In Cunniff, the case involving the city of Seattle, the court also concluded that the legislation that was enacted was too broad. It covered more than a single subject, and our Washington Constitution prohibits that. That may be an issue that comes up in the course of our conversations yet. But the bottom line here is there are a multiplicity of potential challenges to this particular enactment. And I think a court in Klickitat County is going to be receptive to that, and the appellate courts will then have the opportunity to review that decision from the trial judge in Klickitat County. We look forward to making that argument on behalf of our very respective clients.
Perfect. Thank you both. I'm going to turn it over to our plaintiff statements. We're going to start with Mike Sotelo, who is the co-chair of the Ethnic Chamber of Commerce Coalition. Mike?
Sorry, I had to unmute. Hi, my name is Mike Sotelo. I'm president of the Ethnic Chamber of Commerce. We have roughly about 2,000 members and affiliates that work within our organization. We're strongly opposed to this new tax. It will definitely impact our family businesses. Most of our companies are generational, and this truly will affect them long term. But more importantly, is that we've been victims of a number of different laws in the past where we were told that there was going to be a benefit, and that hasn't happened. I mean, not once. And so it's a matter of trust. The governor's bill is saying things that are so vague, and so unclear that we know that something else is going to happen. We're concerned that just following the history of what the legislation have done over the last several years, if it's consistent, we're going to get caught up in this thing, and it's going to hurt. Really what it comes down to is that there's been several votes of the people that said that we don't want this to happen, but we've been ignored. Now we're asked for someone to trust them. That can't stand. All of us need to go against this because it's not good for business. It's not good for families. It's not good for Washington. Thank you.
Thank you, Mike. Next up, we have Patrick Moran with the National Federation of Independent Business.
Thank you, Paige. My name's Patrick Moran. I'm here on behalf of the National Federation of Independent Business, representing small business owners across Washington state. Small businesses are essential to our economy. They're the job creators, the risk takers, and the families who invest everything they have into keeping their doors open and their employees paid. What they need and what they deserve is stability and predictability. When the rules are clear, small businesses can plan, grow, and compete. But when those rules are stretched or ignored, it creates uncertainty that hits small businesses first and hardest. That's why this case matters. This is not just a legal debate. It's a question of whether the state will follow the same constitutional rules that every Washingtonian is expected to follow. Small business owners don't have the luxury of operating in gray areas. They have to make real decisions every day about hiring, expansion, and investment based on the rules as they're written. When those rules become unclear or subject to reinterpretation, it creates real risk. And for many businesses, that risk can mean the difference between growth or relocation and closure. We spoke with our members about the impact this tax will have. We heard from a meat and seafood market that believes in buying local. Instead, they're contemplating leaving the state entirely. We also heard from a small law firm that wants to pay its employees bonuses in recognition of their hard work. But if this tax stands, that money is going to go to the state instead. NFIB is proud to stand with our members and our partners in this effort to ensure that Washington's Constitution is upheld and that small businesses are not left footing the bill for policies that fall outside of those bounds. At the end of the day, this is about fairness, accountability, and protecting the people who keep our economy moving. Thank you.
Thank you, Patrick. Okay, we are going to move on to the Q&A portion. You are welcome to direct your questions to Rob, Phil, or Jackson. I see a hand is raised already. Go right ahead.
Hi, this is Carlene with the Center Square. I wanted to ask you, Rob, some comments that Governor Ferguson made to a local TV station, basically very dismissive of you, in particular saying, you know, every time I've had to face Rob on any challenge, we've won, he's lost, he'll lose again. I just wanted to get your reaction to those comments directed at you.
I think it's very telling that Bob wants to personalize this and doesn't want to address the legal issues involved here. He was Attorney General. He's a lawyer. He understands what it means to have plain language in the Constitution and to have a series of Supreme Court decisions. This is not a boxing match. This is an important question of law, but he doesn't want to talk about the law. Instead, he signed into law a bill that clearly violates the law today, which is why he and the legislators who voted for it need the Supreme Court to change the law for them. And as of the day they voted for it, it was illegal. It violated the Constitution. And unlike former governors like Dan Evans, who had the courage and political skill to put together a coalition to put this to the voters as a constitutional amendment, Governor Ferguson was unable to do that. And the legislature was unable to come up with the votes to send a constitutional amendment to the voters either. Instead, Governor Ferguson and the legislature are working hard to keep this issue away from the voters. And all voters ought to be very concerned about that.
Paul, go right ahead.
Good morning. I'd like to cycle back to the 2019 case on the Seattle income tax. My memory of that, and I haven't read it since it came out, was that the appeals court threw out the underlying statutory ban on the income tax on the single subject rule, and while conceding the precedent, more or less begged the Supreme Court to overturn Cullen. Am I misremembering that?
I think you are to a degree, Paul. I think the decision from the Division I of the Court of Appeals, Judge Jim Verellen wrote it. He basically said, look, there's a two-subject problem in this enactment, so it's unconstitutional for that reason. He said the underlying tax, the proposed income tax, graduated income tax that the city of Seattle attempted to impose, also violated the uniformity principle that both Rob and I have spoken to. So the opinion touched upon both of those issues. The parties in that case, the city of Seattle in that case, then petitioned the Washington Supreme Court for review. The Supreme Court turned them down. So the Division I decision stood. The Supreme Court had an opportunity to weigh in then, and it chose not to. Bottom line here is that the Kunith decision covers both of those issues, single subject and the question of the uniformity clause.
Let me just build on that a little bit. Phil is right, Paul. The Court of Appeals found that precedents under the Constitution from the Supreme Court are quite clear. That goes to the issue of income as property. The second issue in the case was that there was a statute enacted in about 1984 by the legislature prohibiting local and county income taxes should they ever become possible. And of course, they were possible, all along. If they had passed an income tax at 1% that was uniform, that would have been allowed. But that statute from 84 said cities and counties could not enact any income tax. And it was that statute that the Court of Appeals found violated the single subject rule. Because that bill, that prohibition was contained in, had lots of different objects, lots of different purposes. And this bill we're talking about here today does also.
It's true, certainly.
I see we have another hand raised. I just want to, I got a message from Mario Lotmore with the Linwood Times. His mic is not working and he asked me to read his question for him. This is for Jackson or Rob. Governor Bob Ferguson is the state's former attorney general and is no fool to constitutional, quote, envelope pushing. He knows income is property and progressive income taxes are unconstitutional under existing law. Could he be doing this knowing the courts will deem the income tax unconstitutional, paving the way for the courts to confirm that an income tax must be applied to all residents and not just the top 0.25% of Washington state earners? What are your thoughts that he may be exploiting the legal system for implementing an income tax on all residents instead of just the 0.25% to keep the state solvent and resolve looming budget shortfalls?
Phil, should I start on that? And then
Yeah, go ahead.
Okay, so look, I think what's important to understand here is that this case is not about the current income tax alone. This case is about whether or not the state legislature and the governor will have the ability to pass and sign into law future income taxes that apply to everybody in Washington state. They've started by limiting this tax to a subset of taxpayers. But if they're successful in getting the Supreme Court to throw out precedent after precedent after precedent and to ignore the plain meaning of the Constitution and to ignore the voters' will, which has been clearly and emphatically expressed 10 times, then the door will be open for them to expand this tax to as many taxpayers as they choose, because the Constitution won't mean what it's always meant. If they get the decision they want. But, I agree with Phil, and I think we can trust our Supreme Court to uphold clear and clearly reasoned precedent to respect the language in the Constitution. And also, they'll understand that this is the way the voters have understood it and wanted it since the Constitution was originally amended to expand the definition of property.
To put the exclamation point to Rob's remarks, and I agree with those, basically the issue of uniformity, that income as property is the linchpin. If that principle that was established in the multiplicity of cases that Rob has referenced goes out the door, then the legislature by statute can enact whatever it chooses to enact as a graduated income tax. It has complete and utter discretion at that point to be, to tax whatever it chooses to tax at whatever level. So it is the linchpin issue to the question, and if that linchpin issue is resolved favorably to the legislature and governor's position, then there's simply no inhibition on how far the legislature can go.
Yeah, and they'll also have the power to empower cities and counties to pass income taxes. And as you know, in many states that have income taxes, other jurisdictions have been allowed to pass income taxes as well. I would be surprised if Seattle wasn't first in line to request the authority to pass their own income taxes again, if the state prevails in this case.
Perfect. Jim Brunner, I believe you are next.
Hi, can you hear me?
Yes.
We can hear you, Jim.
Thank you. First of all, I'm wondering if a copy of this has actually been sent to us. I haven't seen it. Secondly, why Klickitat County as the initial jurisdiction, and how do you see the timeline playing out in terms of how quick this would get adjudicated by them and then up to the state Supreme Court? And then lastly, if I could, on this issue of the legislature and the governor signing this into law, even though it goes against past court precedent, how do you juxtapose that with efforts by state conservatives who have passed many laws in many states, knowing for years they violated the Roe v. Wade precedent, but they did it in an effort to try to change that precedent? How would you compare and contrast that?
Let me talk a little bit about the procedures, and then Rob can weigh in as well. Just so people understand timelines in this regard, when you file a complaint in a particular jurisdiction in Washington, the court has certain guidelines in terms of timing for handling that matter. You file the complaint, the other side has an obligation to answer it within a certain amount of time. And then the parties usually agree in conjunction with the trial judge for a schedule for addressing the issues and setting up that time frame. The judge in this case will very likely have that kind of conference with the parties and set a briefing schedule and a date for argument of this issue in Klickitat County. This usually doesn't take place overnight. Usually motions for summary judgment require 28 days notice, for example, to the opposing party. So I would expect that the judge will, in due course, set this case for argument probably toward the summer would be my guess based on where we are from a timing standpoint. And once the judge then decides the issue, either party has the opportunity to appeal within 30 days of that judge's decision. Normally, the parties appeal to the Court of Appeals. In certain special circumstances, they can appeal straight away to the Washington Supreme Court. And it's up to that court to decide if they want to accept direct review or not. Sometimes they do, sometimes they don't. It's fairly rare that they do it. So we hope that the court would take this case on direct review because I think parties want to have a decision from the court fairly quickly. But even there's going to be briefing before the court. The court will set the case for oral argument before it. I would be surprised if the case was fully briefed and ready for argument and set for argument in the Supreme Court much before the first part of next year. And then the court, once it hears the argument, can decide the issue in whatever way it chooses to decide it and takes its own time in doing so. So we can't predict how long it will take the Supreme Court to do it, but that is sort of a broad general outline of how the process is going to work. Rob, jump in on that.
We filed in Klickitat County because one of our plaintiffs is the Yakima-Klickitat Farm Association. Another one of our plaintiffs is a farmer in Klickitat County. As to your last question, Jim, it is ironic that members of our legislature who are strong critics of other state legislatures who passed the laws that you referred to are turning around and committing the same sin of passing a bill that they know violates the laws that currently stands. And instead of doing what all the prior legislatures and governors did that wanted a progressive income tax and sent a constitutional amendment to the ballot, they've chosen to follow the same course that those other state legislatures have followed and pass a blatantly unconstitutional and illegal act.
Jim, I wanted to also mention in response to your question about the complaint, it's being filed as Rob mentioned as we speak. We'll make that available to you and the other members of the press along with a press release shortly after this press conference is over.
Thank you.
Next up, we have Brandy Cruz with Undivided Media.
Good morning, everyone. I definitely don't expect you to speculate on the answer to this question, but I thought Phil and Rob, just from a legal perspective, Rob, you laid out all of the precedent here and the voter decisions and the court decisions, et cetera. And you know some of the players. I mean, you know Governor Ferguson, certainly you know some of the members of the legislature who obviously had to have had some legal conversations behind the scenes. Why do you think they believe this time will be different?
They seem to believe that the members of the current Supreme Court will do what they were unable to do themselves, which is to amend the Constitution. And yet they know that the Supreme Court is not it does not have that role. The Supreme Court gets to interpret the law and apply it. It includes interpreting the Constitution, but they don't get to rewrite the Constitution. They know that. The governor and the legislators who voted for this bill know that, but for some reason they hold out hope. So this is the first legislature and the first governor I'm aware of since we've had the current Constitution in place that has chosen to bypass the voters, bypass the constitutional amendment process, and pin all their hopes on the Supreme Court. There have been other efforts, to pass excise taxes in the past and that look a lot like income taxes, but this is the first time they've passed a bill which clearly and explicitly creates a graduated income tax, which the Constitution clearly and explicitly does not allow if it doesn't follow the rules for property taxes.
Mr. Talmadge, any thoughts on that? And then as an additional question for you, sorry to interrupt, an additional question. As a Democrat, and you also know some of the players here, any concerns about, losing friends, losing potential clients down the road for taking on this case?
Well, I'm legal counsel to the Ethnic Chamber Coalition. My job these days is to act as legal counsel, and I've acted as legal counsel on prior matters, as I've described in Cunniff. So I take on popular and unpopular issues all the time. It's part and parcel of what I do on appeal, whether it's representing, victims of child abuse against the state, representing people who've been victimized by offenders that have been released by the Department of Corrections improperly, a number of other kinds of actions where I take on the state of Washington, and so it's not new news for me to do that. The bottom line in this case, in terms of what motivated the legislature to do this, what motivated the governor to sign it, we can only speculate. I mean, Rob's speculation is just as much as mine, a speculation. You can certainly ask the legislators that were the supporters of this, ask the governor why they chose to approach this in this fashion. It's sort of on them. All we can do is present the appropriate legal arguments to the Supreme Court. I know the Washington Supreme Court, I know from experience having served there, that the justices of the court take their job as justices of the Supreme Court extremely seriously. They are aware of precedent. They follow a principle called stare decisis, which means you follow the principles of prior decisions in making your present decision about a case. And they take stare decisis very, very seriously. They will take these issues up in the appropriate manner. They will be serious about it. They will be serious about the arguments that the parties present, and they will make their decision accordingly. But to assume that they will simply do the bidding of the legislature and the governor is a diminishment of the responsibility and role of the Supreme Court, their independence, their integrity, their ability to follow principles of stare decisis. The court takes all of those issues very, very seriously.
Next up, we have Jerry Cornfield.
Thank you for taking my questions. Couple in a row. First, can you just again remind me who is the lead plaintiff in the case, and will they be subject to the income tax should it be upheld? If you could clarify who is funding the lawsuit. And then I had a question about the section that actually creates the income tax. It doesn't have a rate. I'm wondering if the court could determine that the section creating an income tax, that language is legal, the percentage would be then 9.9%, and then somewhere else is the standard deduction. So I guess I'm wondering, by splitting it up in that manner, does it potentially meet legal muster?
I can jump in on the funding question first, and then we'll defer to Rob and Phil on the remaining questions. Jerry, we have been overwhelmed since we've announced that we've retained Rob and Phil in this matter with incredible support from large and small donors around the state. So we're a nonprofit, and so we have just seen an outpouring of support. Obviously, litigation is expensive, and so, anybody that wants more information about the lawsuit can check out our website at citizenactiondefense.org. But, it's been a variety of support from large and small donors throughout the state. And then Rob and Phil.
Yeah, in terms of your point about the percentage rate, Section 201 of the bill states that only individuals are subject to payment of the tax, which equals 9.90% multiplied by an individual's Washington taxable income. So it does establish a percentage rate that kicks in this bill with the first dollar over $1 million. And then you wanted to know about the lead plaintiff. Ben and Laura Petters are builders, and yes, they are subject to the tax.
Okay. We have a question in the chat from Tom Edwards. He said, will this be decided by these justices or the ones elected in November?
Well, taking the timeline that I laid out for you, I think based on what we can sort of anticipate, it will probably be the justices that are elected in November that will be hearing the case. We know that, of course, there have been some changes in the Washington Supreme Court. There have been some retirements, some new judges that were elected in the fall election. Justice Mungia, for example, was just recently elected. We have recent appointees, Judge Melody and Justice Melody, and we're going to see new justices come to the bench because Justice Madsen is retiring, and Justice Johnson, his position will be up for election this fall. So I think the likelihood is, given the time frame that we're talking about, unless things were to move far faster than I suspect, I think it's more likely than not that the judges elected in November will be the ones that will be hearing the case.
Up next is Casey Murray.
Hi, I just wanted to kind of reiterate a question of mine that someone else just asked, but the structure of the tax is technically that the tax applies to everyone and then there's a standard deduction. Do you guys think that will be effective in making the tax legal, essentially?
Well, the tax will be illegal, notwithstanding that structure, because it doesn't follow the rules for property taxes. It's above 1% and it's not uniform. So no, it is illegal under that structure.
That's the argument that we'll be advancing. I mean, plainly, if you're talking about property taxes, I mean, property taxes run roughly 1%, like Rob's talking about. So if you have something that's taxed at a rate of 9.9%, even just plainly at that, you've got an issue. And then you have the graduated effect of the $1 million exemption.
Right. It's not uniform because the first $1 million is exempt. So you have two rates here, 0% on the first $1 million and then 9.9% on every dollar above $1 million. That's how it is not uniform. There was the same problem in the Seattle income tax, by the way. They had different exemption levels, but same issue.
All right, up next we have Alex with King 5.
Thank you. Yeah, King 5 reporter Alex McClune. My question is about how this kicks in 2 years. What can you say about the work that would play out over the next 2 years? Is there enough time, 2 years?
Enough time, Alex, for the state to establish the administration to impose the tax? Is that what you're talking about, or for the litigation to go forward?
For the litigation to prevent the millionaires tax from kicking in 2028.
Well, you heard my time frame, and I think there's ample time for the courts to consider the issue prior to 2028. The Supreme Court, the trial judge, and the Supreme Court will both be highly cognizant of the timeframes that are involved in the case. They will be aware of the practical realities of a need for a decision from them on the tax. So I'm not concerned about this being a situation where we would be seeing a decision butting right up against literally the day that the tax becomes effective, because the courts are aware of the practical realities of things. So I think we can anticipate that, even though the process is not immediate like we see on Law and Order or something on TV, nevertheless, the courts are going to get to the issue, appropriately, and will be aware of the time constraints that they face.
Okay, we have a couple of questions in the chat. The first is with Alejandra Guzman. She said, for Talmadge, speaking as a former justice, can you share how you view income? Is it property? And would this now make the upcoming November election one to watch and one people will be interested in, since justices usually run unopposed or folks don't tend to really keep an eye on? The next question she had was for Rob McKenna. She asked Governor Ferguson about going up against him, and his response was that he made it personal. You had answered this question earlier, but I don't believe Alejandra was on. So I'm going to go ahead and, Alejandra, if you can refer to TVW's live stream for that question. He actually answered that at the beginning. So Phil, if you don't mind answering that first question, though, that would be great.
The first question was, run me back by that again, Paige.
Of course, yeah. Sorry, it was a long one.
Yeah.
Speaking as a former justice, can you share how you view income? Is it property, and would this now make the upcoming November election one to watch and one people will be interested in, since justices usually run unopposed, or it tends to be races that folks don't tend to keep an eye on?
Well, my personal opinion about income as property is irrelevant. The question is what the courts have determined to be the principle that applies. And the principle that applies in Washington courts is income is property. That's been true since the 1930s, when there was an attempt to enact a graduated net income tax by statute in the legislature that was struck down in a couple of instances by our state Supreme Court in the early 1930s. So my personal opinion, one way or the other, is irrelevant. The issue is what the Supreme Court has seen the question to be. And then with respect to your question about, will this fall's elections about justices of the Supreme Court be extra specially consequential because of this litigation? To some extent, that's true. There are already candidates who have filed for the various positions on the Supreme Court. This issue will be something that I suspect could come up in those Supreme Court campaigns. And it might be a situation where the Supreme Court elections, that sometimes are not highly visible, they're down ballot kinds of elections, will have very significant attention and consequences for the voters in Washington state. People should give careful attention to whomever they elect to the bench, whether it's the trial courts, the superior courts, the Court of Appeals, or the Supreme Court, in any event. But I think it might be especially significant this year in these Supreme Court elections, where there are a number of candidates vying for these seats on the Washington Supreme Court with these consequential decisions looming.
On that question of, is income property, this is not an abstract issue. This was decided by the voters of Washington state when they enacted Amendment 14 to the Constitution in 1930. And the express purpose of that amendment was to expand the definition of property to cover everything, whether tangible or intangible, subject to ownership. And income meets all three of those tests. And every Supreme Court panel that's looked at the question has reached the same conclusion. Income is subject to ownership. It is part of everything. It is an intangible. So this decision was not decided by philosophers. This decision that income is property was decided by the voters of Washington state, who wanted a property tax that would be as extensive as possible, that would reach every form of intangible property: stocks, bonds, money, income, all of it. That's why they didn't put a list of items in the definition of property that said, well, this is property, and this is property, and this is property. They said everything, tangible and intangible, subject to ownership, is property. So unless you think you don't have an ownership interest in your income, you have to see that income, in fact, is part of property. Now, in 1934, just a year after the first Supreme Court decision striking down a graduated income tax, the voters had a chance to amend the Constitution again. They were presented with a constitutional amendment that would have excluded income from the definition of property. They rejected it by a wide margin. And just as they rejected 5 subsequent constitutional amendments that would have made a graduated income tax possible. So the voters clearly preferred this broad definition of property that encompasses income from just within, reaffirmed that within just a few years of the original amendment being adopted.
We have an additional question from Tom Edwards in the chat. It says, Jamie Peterson on the Senate floor said that income is not property. The bill is structured as an excise tax because it says it is on the receipt of income. What's the flaw in his argument?
The bill doesn't contain the word excise. Let's start with that.
Yeah,
when you want to create an excise tax, you have to actually say we're creating an excise tax. That's what they did with the capital gains tax. They structured it as an excise. Applying to transactions involving property. They didn't do that here. So Senator Peterson's statement is demonstrably false.
Well, on top of it, the legislatures can describe something in any way they want to. In this case, as Rob points out, there's no mention of an excise tax. But to scroll back in history, the initial effort by the legislature to impose a graduated net income tax was struck down on uniformity clause grounds. The next session of the legislature came back and said, we're going to pass an excise tax on income, and that will get us around what the Supreme Court did. the Supreme Court in that next decision said, oh, come on. We didn't fall off the turnip truck last week. This was an income tax. However you describe it, however you try to characterize it, it's still an income tax. And they struck it down on uniformity clause grounds. So the opinion, I respect Senator Peterson to a great degree, but the opinion of a single legislator on this topic, it goes against the principles of the bill itself, the language of the bill itself, and it has problems in terms of reaching back into history of how we've treated a graduated net income tax in Washington.
All right, we have another question from Colleen. Go right ahead.
Hi, thanks. I appreciate it. I don't know who wants to respond to this, but what do you make of the fact that in the bill, Department of Revenue staff is greatly increased right away to sort of plan for implementation of this, even though we're a ways out yet? What does that tell you about their intentions for this tax?
They intend to implement it if it's upheld. I don't know if it's any more complicated than that.
Yeah, I agree. I mean, I think it's just that simple. It's no surprise the legislature wants the money and they intend to proceed, and they're going to do that and get ready to do so as they move along.
Yeah.
Okay, we have a few more minutes here. Are there any final questions?
Well, thank you all for the opportunity to present here.
Yep. Thanks to CADF.
Particularly grateful for TVW and covering this live and the audience there. And so appreciate everybody's attendance.
As they've noted, there will be a copy of the complaint made available to all of you. I will be sending it out with the press release as well as posting it on our website. In addition, I'm sure many of you will have more questions as you write your stories, and you might have some interview requests. Please feel free to contact me directly with any inquiries. You can reach me via email at page@citizenactiondefense.org. I will put that in the chat as well, along with my phone number. So if we don't have any further questions, I think we can call it here.
Thank you.
Thanks so much, everyone. Have a great day.